Alrighty, this way the people news. Alright, we're gonna finish up on this about the warrants and really how it's supposed to be. Just like my other video. Alright. There's 5 elements. All must be present before they can issue it. But they've been ignoring half of it due to our ignorance. And apologies to y'all. Internet apparently went out, so I thought it didn't upload my video. And I redid it and called it a different name and all that. So, my bad. Sorry. And I don't know how to wipe it off there. So, let's finish this up, okay?
The other aspect that you kind of both have talked about at this point is convenience. And on the one side, Jared, as you were explaining, it sounds like it's pretty convenient still for the government to get a warrant. There's all of this technology and things like that. Doing it correctly seems not that hard, honestly. Right. But I could also imagine that the government in cases like this is going to say, oh, well, we can't be bothered to, clear all of these boxes in this rigorous way because, there's a lot of technology now and things move quickly and we have to be able to, whatever, who knows. And so how does that sort of balance out? Is there a legitimate concern here that this is overly burdensome of an expectation for the government?
I think very few cases relatively rely on confidential informants or all these scenarios we can dream up that would make it harder on police officers. In the run-of-the-mill case, it's just the cops aren't bothering to collect an affidavit when they could, and that then bakes in this idea that the cops are probably just they're getting this information secondhand, thirdhand. No one's actually going down the line and questioning where the information came from, testing its veracity in any way. And so then we're ending up in this situation where in 80-90% of cases, cops, when they have every ability to bring the affiant forward, instead they're not. And so now courts aren't even questioning anything anymore, and they're able to get these warrants on much less than probable cause. Yeah, so I brought props with me today. We have a case at More Retaliation. 2 of our clients were school board members who were arrested for violating the Open Meetings Act. And the allegation was that these 2 women, because they're both members of the same government body, couldn't have private phone conversations. And that was a crime. And so
if one of them calls the other one to just have a chat, that counts as a government meeting that's supposed to be open to the public.
That's right, even though it didn't satisfy the warrant or the quorum requirement. So it was wrong for all sorts of reasons, but the one we're going to hone in on today is the oath or affirmation piece. And so they didn't even know that these phone calls were answered. They subpoenaed their phone records and they saw that there were 40 calls going back and forth that didn't have duration. It didn't have whether they were picked up or anything, let alone the content, what they were talking about. And what the officer said was, it is believed Digman and Jackson held private conversations regarding the vote and outcome of the superintendent vote.
And see, that's what Texas are doing. They're allowing cops to do. It is to believe. The believe part is what's violating your rights here in the state of Texas. And probably other states. But I do know for a fact here in Texas, it's that one little trickery of word that the government's doing and allowing the cops to do it. Well, I believe.
Could have been calling each other just to say, what do you want me to pick you up from Starbucks?
That's right. They could have been talking about anything in the world, and even if they were talking about the vote, it would have been illegal, so we can put that to the side. But the only piece of evidence that they were talking about this vote is a police officer saying it is believed. And, how are you supposed to test it? Believed by whom? Where did he get this information? Who is swearing that that they know what these 2 women were talking about when they were on the phone? And then a magistrate signs off on it. But then, going further, they then accused Cynthia of a second crime, and they said it has also been reported Cynthia Jackson has made public statements about a grand jury. It has been reported by whom? Who did she make these statements to? Was she a member of the grand jury? There's no evidentiary basis here. There's no one who can actually swear that a crime.
So basically, nationwide, all right, They're basically using the exact same thing of everything, like if it was a CPS worker. Oh, anybody can call, and then they'll come out and allegedly investigate and all that. Well, it's the same principle. That's the reason why you're allowed to call and anonymous. Well, wait a minute. I'm going to have a right to face my accuser. This anonymous crap? No. If you're going to make a claim against me, by gosh, be man or woman to stand forward in the state of court and deal with your case. Deal with your complaint.
Happened. They're just saying, rumor has it Cynthia's done some crimes. We need a warrant to go seize her cell phone and download all of the information off of
So
it.
this is almost a step beyond hearsay. You know, at least in most kind of traditional cases of hearsay, it's Kim told me that something happened. But here, they're not even saying who told them that this is happening. They're just almost stating it like a conclusion.
That's right. Yeah.
So is this sort of failing of the magistrates? Like, how do you get every magistrate in the country to like every single
do their
warrant
job?
that comes? Well, sure, yeah, that's a to not put too fine a point on it or anything. But how do you fix this? I guess is the question.
I think the Fourth Amendment, like overturning Jones versus United States and making the oath or affirmation requirement, which is right there in the text of the Fourth Amendment, you make that mean something and make judges have to actually believe that this person who's coming forward with some evidence has some firsthand knowledge and knows what they're talking about. I think that would be a very good starting point because, like we were saying before, once this...
And I go a stretch further that he's not really saying, but make sure all 5 elements is present and there's a green light to proceed forward. But they're not doing it. They're letting it be green and red. And maybe a hint of yellow in there. But that does not satisfy all 5 elements of the warrant.
Warrant signed, our job to prove that there was not probable cause becomes that much harder because a judge has now signed off on it, and that now has like this sense of official and like someone gave their considered judgment to this, and a judge really believed there was probable cause. So now it's up to us to show that there wasn't, instead of everyone should be able to look at this and know that it violates the Fourth Amendment.
So other courts are treating it as though it still sort of went through this rigorous process and cleared all of these hurdles, even though it didn't. So it's kind of like built on this foundation that doesn't exist.
And police officers are entitled to rely on it because it has a judge's signature. And so that's the laundering that Patrick was talking about.
Yeah, let me actually explain the laundering piece a little bit more. So if you're the victim of a completely made up story that results in your house being searched, you think about it, okay, your neighbor doesn't like you, so he calls the police and says to the officer, Jared did something bad. The officer then calls another officer and tells him that Jared did something bad because this guy told me that. The guy himself, the neighbor, he's off the hook because he told the police the thing, but that's not where the swearing happened. The officer who actually swore to it, he was telling the truth because the second officer told him something, and he's saying that officer told me something. The judge signs off on it. The judge is going to be immune because of judicial immunity. And so at every step in the chain, there's no one to be held responsible. And as Jared pointed out, there are things like the independent intermediary doctrine that say police can rely on a warrant unless they know or should have known that there's a material misstatement in there or some other different ways of sussing it out, but it's extremely limited. And so all of this results in, again, the Fourth Amendment going from being a genuine protection of people's rights to it just being a way to say, if you do this quick box checking exercise, you'll be covered from any sort of liability if and when you violate someone's constitutional rights. And I also wanted to go back really quickly to the idea of convenience. Jared's right, of course, that in the mine run of cases, there's no need for this sort of convenience, but with technology and everything else, there's really no additional problem being created here. If you can just have the person themselves sign an affidavit on paper or even on your phone, a lot of times these warrants are being issued through apps where it takes, on average about 20 minutes or less for a judge to sign off on a warrant. And of course, there are already all these different doctrines built into the exceptions to the warrant requirement. So if there is genuine exigency, for instance, there will be situations where you don't even need to get a warrant before you do what you do. And so there's a ton of other stuff that's already built into the system that means that adding this on top now takes the Fourth Amendment's protection from being kind of limited to being basically gone.
Yeah, and the example that you just gave, it seems like the part that's missing is when, Jared's neighbor calls the first police officer. That police officer should send him a form saying, write that down and sign it and send it back to me, and then he gives that to the judge, right? Like, that's the only thing that's missing here.
Right.
Or the judge kicking it back and saying, hey, cop, go get that guy to write it down.
Exactly. Or the guy could just get on the phone with the judge if the judge wanted to hear from him, or through these apps, that person could be the one that's signing the affidavit in the warrant page of this app. The bottom line is, it seems like any objection to this is mostly an objection that police shouldn't have to do the most basic due diligence by ensuring that you're connecting directly the dots of the complaining witness to the support of the probable cause to the issuance of the warrant.
To kind of like root this back briefly to Michael's case, so this stranger who made these false allegations of menacing, was he ever punished? Was he ever, were there ever charges for, filing a false police report? Or did this guy just kind of disappear into the mist after he leveled his false charges and walked away?
Yeah, I mean, he was out for a walk that night, 30 miles away from where he lived, and as far as we know, he was able to walk back off in that direction without any consequences. And so that night, whatever happened with the women, we don't know, but he was in some sort of altercation. And the result of that altercation between him and other people resulted in Michael being arrested and spending time in jail and having his property searched, while this guy was just allowed to let go with his loaded gun and his dog to walk off down the street.
Yeah, if I could give one more.
Yeah. So this is not supposed to happen in this country at all.
Example, we have a North Carolina SWAT case where it was a wrong house raid case. This family's asleep at night. SWAT team shows up. The evidence that the police...
Again, the guy walked off, just to give backstory. Where's the accuser? Who's the man and woman making a claim? Who's the witness? I want to have my Sixth Amendment brought up to be able to face them and have them being questioned and all that kind of stuff. But no, you go to prison for somebody that's not even available for the Sixth Amendment.
That they were at the right house was that they said the suspect's car was parked in front of the house. The suspect drove a 2007 Sentra that was dark gray. Our clients had a 2017 Altima that was silver. They're different
Sounds
cars.
identical to me.
Different license plates, different registration. But one cop told another cop that's the suspect's car. So then the second cop, who has this secondhand hearsay information, signs a warrant application that says the suspect's car is in this driveway. Wrong house raid ensues.
And don't think that the cops are not doing this on purpose to escape liability. If you look at some of you guys out there, if you look at your own case, you'll see a different name than an officer actually investigated the first one. He disappears somewhere. Then it's the leftover cops. Look at your case. See if this is not true.
Our clients are traumatized. We bring a lawsuit. The affiant, the police officer who signed off on the warrant, his first defense that he makes is, I was entitled to rely on another police officer's observations. The first police officer says, I didn't make any material representations because I didn't sign a warrant. And all of the other police officers say, well, a judge signed off on that warrant, so we can't be held responsible for what happened, and the judge is immune. So now there's just this chain of screw-ups where someone confused a gray 2000 Sentra for a 2017 silver Altima, and our family gets traumatized, and all the cops say, well, no one can be held responsible because no one swore to any information that they personally knew, and that's the problem in the first place.
Well, it's also...
And above everything else, I'll say it again. Who's the man or woman making a claim against I? They get to walk scot-free. And, like these phone calls, or we're going to offer money for information, but you don't have to give your name. All these kind of things are violations of the Fourth Amendment. Your rights.
The reason why hearsay isn't typically admissible in court.
Right.
You learn this in law school, that when you can't question the person who has personal knowledge, when you just are relying on, out-of-court statements, that there are lots of kind of normative problems with that.
Yeah, and I also think to Kim's question earlier about, how will this fix the problem if the magistrates aren't really paying that close of attention, I think that if the Supreme Court were to weigh in on this and revive the oath or affirmation requirement, that would send a very strong signal to every magistrate in the country that no, this actually does mean something, and you should start taking a look at it because this is serious. This is fundamental to, who we are as a nation.
And that reminds me, Patrick, earlier you mentioned that I think maybe on average a magistrate takes less than 20 minutes to review and sign a warrant requirement or a warrant petition. I don't know where you're getting that from, but is there data on, for example, how frequently warrant applications are denied versus granted?
So I'll say that the data that I'm using is,
and above everything else, it's the prison for profit from Ronald Reagan. Is the whole issue about this, trying to get everybody in imprisonment.
From a private company called Cloud Gavel that offers an app-based warrant service that a number of government entities use, and they brag that the average time to wait is 20 minutes, but there are examples where these warrants are being issued after 2 minutes.
Well, so that 20 minutes isn't even like 20 minutes that the judge is looking at it. It's the judge gets an email, and then maybe 19 minutes later opens the email and then just goes boop.
It's 20 minutes from submission to approval. And so that in and of itself seems obviously very problematic. In terms of the statistics, I don't really know. I think it's clearly much more common that warrants are going to be approved than disapproved, and there are a number of other things that are sort of informal to the process. For instance, if there's a judge in your district that gives things a much closer look, you're going to go to the easier judge. This is not a panacea to solve every single problem, but it is a way of restoring one of the core pieces of sort of the machine that the founders designed to help protect us from these sorts of government abuses that now we've all kind of unfortunately gotten used to the point where you can tell, normal people about this, and their first reaction might be the one that I think Jared and I have, but it could also be one where they say, well, you know what, I think that seems reasonable.
And we're going to take it a little stretch further, right? All these things are combated into this one deal. And this is the reason why innocent people are taking pleas for the less charge, because their own attorney can't fight this, right? Because it's been so corrupt. And then all these judges will file bar grievance against an attorney. And they hold weight in gold, or magistrates, or whatever.
And it didn't seem reasonable to the people that wrote our Constitution, and I think we need to revisit the debate that led to the language that was ratified in the Fourth Amendment.
So, sort of wrapping up, I'm wondering if you guys can kind of put this, oath or affirmation issue into the context of our broader Fourth Amendment project, because it occurs to me that we have all of these cases saying, officers should have to get a warrant, law enforcement should have to go get a warrant to enter your private property, even if it's technically a, open field. They should have to, get a warrant to do all these things. What it sounds like what you're saying is that those warrants kind of, don't really mean anything, right? And so why is it significant that we would, stand so firm even on the ground of you have to get a warrant in the first place, if that's just kind of a, rubber stamp kind of process?
I think fundamentally the answer is
The answer really is, it's an illusion that you actually have a Fourth Amendment. It's an illusion that you actually have rights in this country. It's a socialized country. You just believe it's not.
Take the text of the Fourth Amendment, which anybody can read, it's not a lot of words, and you kind of highlight the different clauses that are in there, and you color them from green to red, from good to bad, as far as whether they're being actually enforced. Our goal with the Fourth Amendment project at the most basic level is to get all those words to turn green. And it might be the case that just getting the oath or affirmation to turn from red to green is not going to solve all the other problems. But as I mentioned earlier, this is a machine that was designed with several parts by the founders, and we need to get all the parts working again. And so what we shouldn't do is kind of view every one as if it's making or breaking the system and say, well, what's the point of the Oath or Affirmation Clause because there's still this problem or that problem? Well, we can fix those problems too, and we will. We will continue to fight that fight. But the goal is to turn our Bill of Rights from red to green, and then we can discuss as a country, is this good policy or bad policy? Is this outdated? Does this need to be updated? And if it does, then you can go through the amendment process and make those changes. But what we shouldn't do, and what we have done as a country, unfortunately, is watch the language that has been ratified turn from green to red over the last 250 years.
In terms of
All right, we're going to go ahead and end it there, y'all. So this is the Institute for Justice. If you can, donate to them. Help